In the second half of the 20th century, many Latin American countries adopted a legal doctrine that shaped how the state intervened in the lives of children and adolescents. It was called the Doctrine of the Irregular Situation, a concept that would come to define juvenile justice systems across the region. At the heart of this doctrine was a distinction between children who were simply minors and those considered to be in an irregular situation. This label applied to any child who found themselves outside what the state viewed as a normal or acceptable condition. Children could be classified as being in an irregular situation not only for committing an offense, but also for being homeless, abandoned, orphaned, poor, or in a situation of moral or family risk. In other words, you didn't have to break the law to be treated as if you had. The doctrine was not developed in a single country, it emerged through transnational discussions, particularly those promoted by the Inter-American Children's Institute. Throughout the 1950s, 60s, and 70s, the Inter-American Children's Institute organized regional congresses and published technical documents advocating for a model of juvenile intervention based on social control, tutelage, and institutional correction. The child in an irregular situation was seen not as a rights holder, but as an object of protection, or discipline depending on their perceived behavior or social condition. This model had deep ideological roots. It was built on the foundations of social hygiene, legal paternalism, and a welfare-based logic that emphasized correction over autonomy. It reflected a worldview in which poverty, street life, and family instability were treated not as consequences of inequality, but as signs of personal or familial failure to be corrected by the state. One of the most influential legal codifications of this doctrine occurred in Brazil, with the promulgation of the Código de Menores of 1979. This law explicitly adopted the doctrine of the irregular situation as its guiding principle. It defined minors as either in a regular situation or in an irregular one, with the latter encompassing both criminal acts and conditions of vulnerability. Under the 1979 Code, judges had broad discretionary powers to institutionalize children in shelters, correctional facilities, or reformatory programs, not based on due process or legal judgment, but on an evaluation of their social condition. No trial was necessary. Legal defense was not guaranteed. The goal was not justice, but social readjustment. The doctrine allowed the state to bypass ordinary legal guarantees by classifying its actions as protective. But in practice, it led to the mass institutionalization of poor and racialized children, reinforcing systems of marginalization and control. This legal framework spread throughout Latin America. Versions of the irregular situation doctrine appeared in the juvenile codes of Chile, Peru, Argentina, Uruguay, and others, often promoted as modern, humanitarian alternatives to adult criminal justice, but in reality, reinforcing social exclusion. The Inter-American Children's Institute played a central role in legitimizing this model. Through its publications and congresses, it advocated for early identification of children at risk, and for the expansion of state authority over families, especially in contexts of poverty or nonconformity to dominant moral norms. The doctrine's influence began to erode only in the 1980s and 1990s, under pressure from emerging human rights movements, post-dictatorship legal reforms, and the growing authority of international instruments, especially the 1989 Convention on the Rights of the Child, CRC. The CRC introduced a radically different perspective. It recognized children as subjects of rights, entitled to due process, freedom of expression, participation, and protection without discrimination. It rejected vague legal categories like moral risk or irregularity, and called for justice systems that respected legality, necessity, and proportionality. In Brazil, the 1979 Code was eventually replaced by the Estatuto de Criança e do Adolescente, ECA, in 1990, formally ending the doctrine of the irregular situation. But the legacy of that doctrine, in institutional culture, in public discourse, and in everyday practices, still echoes today. The doctrine of the irregular situation reminds us that laws created to protect can easily become tools of surveillance, punishment, and exclusion, especially when applied to those already pushed to the margins of society.